Hello, good morning. Thanks for coming on a Friday morning. I hope you enjoyed the conference, and we are very happy to be here today. I'm very happy to chair this panel. My name is Emilia Gomez. I'm lead scientist at the European Center for Algorithmic Transparency. Our center supports with scientific and technical work the enforcement of the Digital Services Act. And one of the files we have been working on is Article 40, so it's the data access. And as you may know, the research linked to data has been limited by the possibility to access data from products, and in this case from online platforms. So researchers and the research community has been limited in that sense. And the Digital Services Act offers the great opportunity now to ask platforms for data to carry out research. And this is about this is the topic of our panel. We are in CPDP, so there is a special focus on data protection, and we wanted to explore also the data protection considerations linked to this sharing of data, especially as researchers must comply or with certain conditions on protecting personal data when accessing data for the research. There were some questions we would like to address, for instance, which are the tools and infrastructures and procedures that should be implemented to ensure data protection in this particular context, which are the interdisciplinary collaboration that needs to be established between legal and technical people, and also which are also the mechanisms that are being put in place to practically implement this article. So I'm very happy to have a great core of panelists. The panel will be organized as follows. We will have a short presentation by each of the speakers that I will now introduce. Then we will ask them a few questions related to the particular perspective that they are bringing, and we will then follow up with questions you may have and considerations, so to get as interactive as possible. So this is more or less the structure. So we will start, I think, with the next speaker. It's my colleague Veronique Simina. She works at DG Connect, the Digital Services Act unit, and she contributes to the supervision, enforcement, and monitoring of the Digital Services Act. And prior to that, she works as a legal officer in the Policy and Consultation Unit of the European Data Protection Supervisor, where she provides advice to EU institutions on legislative and policy proposals regarding data protection. So her expertise is much linked to the panel. Before that, she was a legal intern in the Supervision and Enforcement Unit at the EDPS and a legal assistant in private practice in Rome. And she holds a master's degree in European law and a bachelor's degree in political science and international relations. So thanks, Veronique, for joining us. I mean, we would like to ask you, I mean, you are bringing the regulator perspective, so can you update us a bit on the status of play of this work and also considerations that you may consider relevant?
Thank you. Thank you very much, Emilia. I hope you can hear me well. And pleasure for me to be here at CPDP, which is indeed one of my favorite conferences every time. From our side, the work, as you may know, the DSA contains a specific provision, namely Article 40, that deals with data access. So in this context, there are indeed three types of data access reflected in Article 40. One is indeed reflected in Article 41. So the VLOPs will provide data for monitoring and assessment of compliance with the DSA obligations to the Commission and the Digital Services Coordinator of Establishment. Another one is reflected in Article 40.4, so namely the aspect related to vetted researchers. And here this reserves, let's say, the right to researchers that fulfill specific conditions to be granted access to non-public data only for research projects that contribute indeed to the understanding of systemic risks within the EU. And then another one which is related to, which is reflected in Article 40.12, that refers to access to public data for researchers and CSOs, and protects those who use automated means such as scraping to study EU systemic risks. Now, our work is currently focusing on the preparation on, for a delegated act, which will focus specifically on the vetted procedure, so the data access for vetted researchers under Article 40.4. The same article empowers indeed the Commission to adopt a delegated act to set out the purposes and procedure for such access by researchers that would be vetted. Now, the process so far has involved a call for evidence, initially carried out in 2023. We had 133 replies to this call for evidence. The actors who responded were very diverse. We had academics and research institutions, non-governmental organizations, but also EU citizens, companies and businesses, and also indeed public authorities. The main findings that we have derived from this analysis and from the call for evidence mainly reflects the need for a broad scope of data access, the need for a common application format and uniform vetting procedure, but also the importance of involving researchers in the drafting of the Delegated Act, appropriate security and data protection safeguards that need to be ensured in this process, but also the importance of access to publicly available data. So also given this public, this call for evidence, this has indeed informed our work, which is ongoing. We have involved in the process of the drafting an expert pool of experts, indeed contracted with the support of the European Center for Algorithmic Transparency to work on both legal and technical aspects. We have engaged with in technical discussions with specific stakeholders. And we have, including digital services coordinators, so the proto-DSCs before they were officially nominated, but also a wide outreach to the research community. So this feedback and this work has led indeed to the work on this Delegated Act, which is currently ongoing, will be made available for public consultation in the next month, most likely. So this is still tentative, but most likely that will be the timeline. And just briefly to outline a bit what to expect in the context of the Delegated Act, there will be, the Delegated Act will present some sort of journey, both in chronological time, but also reflecting the actors involved, starting from the application of the researcher under Article 48 of the DSA, then the assessment of such application from by the digital services coordinator of the research organization, possibly, but also the granting, indeed, of the status of vetted researcher by the digital services coordinator of establishment, and then, indeed, the submission of the application and of the request, with the data access request to the VLOP or VLOS to which the data is being requested. There will be the possibility for the companies to request for an amendment, which will then need to be agreed upon, and then once this procedure will be over, then the data access will be provided to the researcher that has that has requested for such data. And also important last point is the fact that then the research, once it is completed, will need to be, so the results of the research will need to be published in line with Article 48G of the DSA. So of course to demonstrate also the validity. Yes, so I think this summarizes a bit the whole process, so the whole journey, starting from the application to the granting of the data. It's very general, but you will see it more in details once the delegated act is also published. So we, as I mentioned, we divided the delegated act into building blocks. One focuses on researchers, the other one on what the digital services coordinators have to verify, assess, and in order to then grant the data access, and then, of course, the role of the very large online platforms and search engines in providing such access. And then, last but not least, just to mention also that we have also been carrying out and including data access in grievances for 3 out of 4 of the opening decisions that we have currently opened. We have indeed sent horizontal requests for information to 17 very large online platforms and search engines on the 18th of January. We are monitoring compliance of Article 4012, namely access to public data, for all designated entities under the DSA, but also on the basis of the requests for information and the monitoring of formal proceedings, we have opened for X, TikTok, AliExpress, and Meta, and these have included, as I mentioned, grievances on the DSA Article 4012. So this is to give you a bit of a broad overview on, let's say, the delegated act work, but also on the work that we're carrying out with regards to Article 4012 more specifically. So I think I would leave it here and leave the floor to the next speakers. Thank you.
Thank you very much, Veronique, for this nice introduction and also to know a little bit the status and the procedure of this delegated act and the enforcement actions. I would like to pass now the floor to Paddy Lersten, postdoctoral researcher from the Institute for Information Law, University of Amsterdam. He's a postdoctoral legal researcher, and his work focuses on social media governance with a particular emphasis on questions of transparency and data access. He's part of the Institute for Information Law DSA Observatory project, and he has been also in the expert pool that Veronique mentioned on the work on the Delegated Act. So I would like to ask Paddy to elaborate a bit on the legal safeguards that researchers may need to consider when protecting personal data, maybe in the scope of this request that Veronique mentioned. So Paddy, the floor is yours.
Yeah, thanks. Is this on or? Yeah, great. Well, good morning, everyone. Thanks for making it out at this early hour. I have heard Friday morning referred to as the graveyard shift at CPDP, so I'm very happy to see so many of you show up. I have been working, I work at the DSA Observatory, so my specialism really is the DSA as such, but I've been also working on this data access provision, which brings in all these legal fields, including others such as security and trade secrets law, for instance. So there's many other issues that arise with Article 40 as well, but you know, in the spirit of this conference, I'll focus my comments on the data protection aspects. I'll point out one of the pieces of work that's already been published was the summary of the call for evidence that came out last year. I was involved in that very much. You know, it's online and available. I won't speak about it too much here. I think the main point to take away from it right now is indeed the great demand for access we have amongst researchers, right? There really was quite a remarkable turnout for that call for evidence. So that's something to highlight. Also, I will note internationally, a lot of specifically US academics can't wait to get their hands on some of this data, it seems. I also have a paper that just came out with the Weizenbaum Journal for the Digital Society, which is more on the theoretical aspects of data access. So I'll just plug that at the start. So you may, I hope, be aware that Article 40 contains two different data access rights for researchers. One is 44 and subsequent paragraphs, which are the main framework, and then Article 4012 is for non-public access, for public data access. I'm going to focus most of my comments on the main provision on 44, but just briefly on 4012, I will note there is a great report that just came out from the Article 40 Collaboratory over in Berlin, Jakob Ohma and Ulrike Klinger, and it's a very interesting report because it looks at the ongoing compliance there. Because one of the major differences between these frameworks is that Article 4012 is more or less live now, right? There are currently researchers applying for access directly with the platforms. There's an important procedural distinction, right? So Article 44, you apply to the DSC, and Article 4012, it seems you apply to the platform. The DSA isn't very explicit in what the procedure is there. This also immediately raises the point that Article 4012 is read by some as it's something you petition the platform for, and others interpret it as a right to, for instance, do independent collection or scraping. We have seen in the Commission's recent enforcement actions that scraping was mentioned as relevant for Article 4012, so I think that is very much a live debate and open to interpretation. But there are also people taking that other route and applying for access with the platforms. And the great work being done in Berlin is monitoring how those cases are going. I think they count around 26 or 30 applications that have been submitted, right? And the initial expectations, as I think some of us might have expected, are ones of some bit of frustration. You know, there's always kind of growing pains with these things. And the kind of predictable outcomes you see in their report are, for instance, the scope of the right in terms of systemic risks is being too narrowly interpreted. The scope of the vetting is being too narrowly interpreted, and many other things are being too narrowly interpreted. But there is, of course, a procedural factor here, which is that it's the platforms doing the interpretation in the initial step, right? And that's going to be different when we have the Article 44 right, where you petition the DSC. So I will be looking to the DSC to show the more reasonable way of interpreting these relevant concepts when we do get to that point. I think there are also people currently applying to the DSCs. Of course, without the delegated act in place, that's a bit of a tough task for them. How they're going about that is maybe a question I'll look to the other panelists for. So that's what I wanted to say about Article 4012. Now for Article 44, one of the major tasks that the DSCs have in collaboration with the researchers is to devise what are the appropriate safeguards, right? The researchers will have to come up with their own designs, I think, in their application, but it's ultimately for the DSC to decide what's appropriate. And the way I've been going about my analysis in this context, broadly speaking, is that there is already a lot of knowledge in this space. Specifically, the work of EDMO has been very, very useful. The European Digital Media Observatory has been doing great work analyzing data protection considerations for researcher access to platform data. They have a wonderful report from a few years ago on this question. But there is a major change. Of course, we have now the DSA. So a lot of the work that came before was very much premised on an idea of voluntary data sharing. There was not a statutory obligation to share from the platforms, nor a statutory right for researchers to request access. And that changes the analysis in various ways, right? So that has consequences for your processing grounds potentially, right? Public interest becomes relevant. Compliance with legal obligation on the platform side becomes relevant. That filters through into, for instance, how special category data, what exceptions you can appeal to there. So, for instance, one of the things that EDMO really struggled with was that you needed to probably look to national law for a legal basis to perform your special category data processing. And they had a tremendous amount of work going through all these national frameworks trying to find what relevant provisions there were to legitimize scientific processing. Whereas now you can point to the DSA, I think, as your basis, and that, I think, simplifies a lot of the legal compliance analysis you need to do, right? So these are some of the ways. Another one you might point to is controllership, right? If it's a voluntary thing, the platform is very much involved in determining the means and the purposes of the processing still, right? Whereas if it's a voluntary legal compliance issue, I think kind of separate independent controllership probably makes a lot more sense. So these are some of the ways in which having a legally binding framework changes the analysis. Ultimately, on the kind of, these are kind of legal formalities, I would say, on the substantive level, like what kind of safeguards should you have, what kind of data access is appropriate for research purposes, it doesn't necessarily change so much, right? And a lot of this still has to be worked out in practice. You know, you can't really get around the balancing. Even if you have compliance with the legal obligation, there are still norms of proportionality, or appropriate safeguards, respecting the essence of the fundamental rights, these fundamental norms, which still lead to balancing that you can't really get around. So and maybe we can get more into that later, but I'll leave it at that for now. So that's how I've been thinking about kind of the data protection issues being raised by the DSA. I'll close with a kind of a sociological observation, which I find interesting, especially in this conference, to note that the tables have turned in this context a bit. I find it very interesting to see platforms insisting on all these rather strict interpretations of data protection law, right, in these applications. And then we see the civil society kind of on the other end of the table. So I'll just leave that there. I think that's interesting dynamic to see. Yeah.
Thank you very much, Fadi. It all depends on the purpose of the processes, so it's very interesting to know that. I would like to pass the floor now to Kathy Messer to see a little bit the perspective of a researcher or civil society on access to data. Kathy is a project director at SNV in Berlin. She works on approaches to analyze and evaluate recommender systems for internet intermediary, and her focus lies in strengthening the public sphere in digital literacy. And her approach is based on more the technical, sociological, and policy perspective. She's currently working on auditing recommender system in social networks, and from 2019 to 2021, she led the study on digital news and information literacy source, the internet. So, Kathy, which are the challenges that are brought to civil society organizations, not having maybe also the staff and resources that other institutions may have on the scientific and technical side, and what will be the solutions that you think could be taken? And also, following Paddy's remark on the data protection implication, how researchers are currently addressing those issues in order to perform their project? Thanks a lot, Kathy, for that.
Thank you so much for the invitation, and I want to start with your remark, because all of a sudden we are civil society organizations now complaining about the GDPR requirements. So I want to highlight that a little bit, what the requirements regarding data access mean for us as civil society organizations. And I thought I maybe start with a very concrete example what it means for us as a civil society organization to deal with research data. So in the already mentioned, so I work for a Berlin-based NGO, and I did a research project on news literacy, and in this research project, all of a sudden, we had a legal problem. In that case, it was about German copyright law, and the problem in our organization is we don't have like legal advice internally. We don't have a legal department. We only have a lawyer, external lawyer, advising us pro bono, and usually not having the time for specific questions and also not having the expertise for specific questions. So I ended up in a situation where I didn't know what to do, and what I did was I Googled a lot, and then I hoped for the best. And I would say for me it's okay when it comes to copyright law, right? But it's not okay when we talk about data protection. And the problem is, my situation is the situation of many CSOs. And when we don't consider this specific kind of precarity we face in civil society organizations, when we talk about data access provisions, when we talk about compliance with the GDPR, we actually exclude researchers from the access that was actually created for them in the first place. So I worry that this could be the case with Article 44 and 48 in the DSA. If CSOs can apply as vetted researchers, what I currently assume we can, it might be that we do not have the internal structures in place to meet the accompanying requirements. Or rather, the problem might even start one step earlier. It might be that we already struggle to figure out what the specific requirements for us would be. So having data scientists in your team, and as other CSOs here in the room know, it's hard enough to find data scientists as a civil society organization. But even if you have them in your team, you don't have a team of legal data protection experts. And when it comes to data access requirements under the GDPR and the DSA, we do not talk about technical practicality, but we talk about legality. We talk about legal criteria. So the question you asked is, what could help? And I see various potential solutions here in different fields that could interlock. The first, of course, always is, as civil society organizations, we join forces. And there's one project I know of and I highly appreciate is from the German Society for Civil Rights, the GFF. And this GFF project tries to find a middle ground between standardized demands on the one hand and practical needs on the other hand. And their plan is to offer like checklists and templates and model data sharing agreements for researchers from universities as well as from civil society organizations. And one aspect of their work, which is super basic, but for me was quite helpful, is that they broke down the already mentioned quite lengthy and complex ETMO report into checklists and table, for example, to help us figure out the risk category of data, the risk category of our data processing. And for all the data protection experts here in the room, this might be a no-brainer, but for researchers like me, coming from sociological research even, this is super helpful. But I'm quite sure this will not be enough, so I guess we will need the platform's help here as well. An additional solution could be that platforms maybe offer more than what is expected from them, because for instance, they could offer storage for our research data, sandboxes for sock puppet approaches, and data clean room maybe even for medium risk processing. Since we seem to trust platforms even more than civil society researchers, why not ask them to provide secure infrastructures also for research with lower risk processing? And thirdly, you didn't mention it, but there is an ongoing discussion about a potential and widely discussed intermediary body. And there is a working group on that, and there are already efforts. And in my opinion, such an organization could be super helpful for us. But like many others, I also see a pitfall in the fact that this could create complicated, duplicate structures to the DSA obligations, thereby adding to the complexity of the vetting process and actually increasing the workload and the bureaucracy. And that is why I would advocate for an intermediary body not working in favor of platforms or regulations, but actually building a support organization for researchers, helping us with the application process, advising on data protection issues, offering relevant information, helping to set up the project in compliance with the DSA and the GDPR, and all of that as concrete as possible. Yeah, and last but not least, I'm eagerly awaiting the delegated act.
Thank you very much, Kathy, for providing your perspective. I mean, many challenges also from the point of view of researchers. And we wanted to hear also the industry perspective because, of course, there are some concerns and also there is a need to prepare for this challenge also from their side. So we have here Claudia Canelles-Quaroni. She's a senior policy manager at the Computer and Communication Industry Association's Brussels office. And she's responsible for content moderation, political advertising, and the fight against child sexual abuse material. Before joining CCIA in 2023, she served as director at Brussels-based consultancy, where she specialized in platform liability, content moderation, e-commerce, copyright, and audiovisual media policies, or are topics related to today's panel. So thanks, Claudia, for coming here. I would like to ask you a bit, you represent many platforms, and how are you dealing with implementing this provision and preparing for that, and for also this new type of access provided by Article 40, and which also will allow researchers to access non-public data, so which is also the target of the discussion. So can you please give your perspective?
Sure. Yeah. Oh, I hope you can hear me well. Thank you very much, Amelia, and thank you for inviting me. I am here to give the industry perspective. For those of you who don't know CCA, we're a trade association representing a myriad of tech companies, ranging from online marketplaces, search engines, social media platforms, cloud storage providers, etc. A lot of our members obviously fall under the scope of the DSA, some as VLOPs and VLOSes, some not. But this is one of the reasons why we have been so active during the negotiations in the DSA and now in the implementation phase, where we consider that collaboration between all of the different stakeholders involved, with the Commission, but also with researchers, civil society, and development of platforms is really crucial for a correct and effective implementation of the DSA. Since we've heard from Veronique that the delegated act is still not available, I will try to focus mostly on our comments to the draft delegated act and some of the concerns and open questions that we still have and that we hope that the delegated act, we're sure that the delegated act will address. I'd like to focus on three main things. Firstly, on data access needs, then the formats for the data access, and lastly, a bit longer on some of the open questions that we still have. So firstly, regarding the data access needs, this point might be a little bit obvious, but I think it warrants repeating nevertheless. There is already, as Patty also mentioned, a lot of data that is already publicly available. So it's important that the data access requests for the platforms are limited and count with a series of limitations, such as, but not only the fact that the data must exist. Researchers shouldn't ask for platforms to create new categories of data that don't currently exist. We also consider that the data requested should be relevant to identifying and mitigating the systemic risks. We would also like that the data requested does not act to expose any vulnerabilities from platforms and is limited to what the research, the scope of the research is actually. We would also like the sharing of data to not conflict with any other regulatory frameworks within the EU, namely the data protection and privacy rules that we have. And lastly, just to not overburden platforms, and as I said, trying to verify the data that researchers want to request is not already available through other means, either transparency reporting obligations or other proactive ways in which platforms actually publish this data. Secondly, and very briefly, regarding the formats for the data access, we hope that multiple technical solutions will be allowed when setting up the interfaces for the data access, because imposing a very stringent requirement, would actually prevent possibly from a more privacy-preserving interface to be developed and deployed by the platforms in the future. And then lastly, as the last point, as I said, I wanted to touch briefly upon some of the open questions that we have regarding the data access procedure, and that we hope that the Delegated Act will address. Here I'd like to focus on three main things. Firstly, we would like to know how consistency will be ensured in the process and application of the criteria under Article 40.8. We would like to prevent DSCs from having differentiated approaches when it comes to open questions such as what a substantiated application or even systemic risk, as Patty mentioned, are, because as the internet acts globally and most of the online companies act across borders, it's important to have this consistency across the whole of the EU. Secondly, we would like to see more clarity when it comes to the differentiation between the status of vetted researcher and the researcher status under paragraph 9 of Article 40. The whole vetting process we would also love to see a little bit more clarity there. And then thirdly, we would like to know if any safeguards are planned to be introduced to make sure that the data access requests are limited. So in line with the data minimization principles under the GDPR, the requests, we believe, should be strictly limited to the minimum that is necessary and pertinent to the research, and not act to try to expose other types of vulnerabilities from platforms. In this case, and also to help with all of the things that I've mentioned before, we do believe that the independent advisory body that Kathy was also mentioning and EDMO has been promoting would be a very welcome thing and provide the needed flexibility to help providers and also researchers interact even before starting the request for data access. This could help providers help researchers to check whether data is already available, to help with the substantiated application process, even before actually going and requesting the data access, and really help also DSCs and with the participation of, obviously, the Commission. But we do believe that this should be governed by a third independent party. So just briefly to sum up some of the main points that I touched upon, we do consider that collaboration is essential between all of the different actors involved, the consistency in the application within the different member states, and also the respect for the regulatory framework, the rules of trade secrets, confidentiality under the Trade Secrets Directive, etc. Because we believe that it's a joint effort and responsibility to actually have a good implementation of the DSA.
Thank you very much, Claudia, and for your perspective. Last but not least, we have the Digital Services Coordinator. You are by no hazard in the middle of the panel, you know, arbitrating between researchers and platforms, and especially in Ireland, you have a major role in this. So we are very happy to have here Kirsty Park. She's an Assistant Director of Research at Commission Namien, Ireland's media regulator and digital services coordinator, and her work focuses on the implementation of the vetted researchers provisions and the Article 40 of the DSA. She was previously policy lead at EDMO Ireland and a postdoctoral researcher at Dublin City University, where she focused on disinformation and media policy, specializing in the DSA and the code of practice on disinformation. So, Kirsty, how the procedure will work and what is being done to prepare it, because you have a big challenge ahead of you, and can you tell us a bit how are you see this process and in line with the interventions we heard?
Sure, thanks for having me here. It's great to be here. And I will say, implementing Article 40 is quite a mammoth task, as I'm sure nobody is surprised to hear. But I would emphasise too that it is something that we are very committed to at Commission Man. It's something that we're taking very seriously and putting a lot of priority towards. We really want the process to work well, and we see it as being very valuable. So just to make that clear, it is something that and I personally am very passionate about as well. And I suppose where we're looking at it at the moment is very much as a process, thinking about, you know, how do we, what's the sort of pipeline that you deal with when we receive an application? Because there's a lot of different checks and different aspects of it that needs to be considered. There's some of the very practical ones that are listed in the criteria for Article 48, things like being part of a research organisation and funding and things that, some of the more practical aspects, but of course the data protection aspect is probably the biggest one and the hardest one to deal with at the moment. What we're doing at the moment, we're really building up our teams internally. So Commission Man is hiring quite rapidly every week. There's new people coming in the door. We're building up research and data and platform supervision teams, which are all in place to really start to look at this issue in more detail. We also actively are participating with DSC, or other digital services coordinators, and European Commission meetings to really make sure that we're all on the same page to understand the timelines. I think collaboration is very, very important in this process, particularly between DSCs. So that's something as well that we see as being quite important. And we're also participating in various events, academic, European Commission events, CSOs, workshops, things like being here today, I think is really, really valuable. I suppose a big thing to say is at the moment we're really listening. We're trying to take in all the different perspectives and a lot of the different knowledge that's being provided on this, because it is a really multidisciplinary, complex process. So I think that's extremely important. We also participated in an EDMO pilot, and we already had some learnings from that. And there may, of course, be more pilots as well, and we're more than happy to participate in those too. And I suppose something that is very important too is the draft delegated act. I think we're all eagerly anticipating that, and we very much look forward to, I suppose, having more clarity as well on what the exact technical procedures will be. In terms of challenges, a big one is that Ireland expects to process the majority of applications under the vetted researchers process. And for those of you who aren't aware, that's because you can either apply initially to the DSC of your research organisation or to the DSC of the establishment of the VLOP of LOCI, but ultimately the end decision comes to the DSC of establishment of the VLOP of LO. So we expect to have quite a lot for that reason, that a lot of them will be coming our way. And I would say too that does create the potential for bottlenecks. I'm not going to sugarcoat over that. It definitely does, and particularly at the beginning if we start with a very high number of applications. And really what I would say too is to kind of manage expectations on that too. We do expect that at the beginning it will be a slower process. And part of that too, it's not just a capacity issue, but it's also we're dealing with very novel research requests that haven't been asked before, and data requests of platforms that haven't been asked before. And as a DSC, we really want to stand over every one of those. We want to be able to say that we've looked at them in depth and in detail, and that we can say that, yes, that's a fair application to grant. And I think at the beginning that will take longer because it's a new process and we have to figure out exactly how to ensure that we can stand over those. There's lots of data protection expertise needed, legal expertise too, particularly in the amendment process if platforms are coming back and saying that they can't provide data for whatever means. We also have to approve amendment requests in those cases, and so that's going to require expertise to really make sure that we're taking those seriously as well. And also just the scale and the timeframes. At the moment, we're trying to develop processes, but we also don't have full clarity until the Delegated Act is finalised to a certain extent. We don't know exactly what we need to be preparing. And so I think for all those reasons, I would say it's going to be a bit more of a marathon than a sprint. It's not something that to expect to have it all in place instantly, but I want to make very clear that it is something we're focusing on and we want to refine over time. And I suppose too, something to emphasize is, you know, and I think you touched on this a little, that also part of the problem is people don't know what data exists. So it's going to be very hard for people to make assessments of what they need to do in terms of data protection if they don't know what the data is, what it looks like, what parameters it has. That's an added complication. And I would say too, I think platforms can also take leadership on that by releasing details, by providing code books, by doing things that give some clarity to researchers. That would also make life easier for everybody. So I think that's something that platforms can contribute to as well. And of course, researchers will have to show that they can deal with this in a good way, that they have the plans in place. And so ultimately, I suppose we do expect there to be some bumps along the road. Like I say, this is an extremely complex endeavor in many ways, but I think it's something too that I'm very excited about. I think that there's a lot of potential there. There's a wide body of research that can be facilitated through this, and I think too ultimately it's something that once the process is up and running and works well will serve to make the online world safer and better for everybody, and I think that's a win-win to everybody, including the platforms. So thank you.
Thank you very much, Kirsty. I think we have seen all the first introduction and round of perspective by different stakeholders. We see the trade-offs and also the balances that we need to do, for instance, in terms of data protection and also the need to have data that can allow different research and also the need to also minimize a little bit personal data. So I would like to give now the floor again to all the speakers for short intervention, trying to refine a bit their input, also based on the questions that we may have. For instance, I would like to start with Veronique. I mean, there has been some questions about the Delegated Act and in particular how it addresses the data protection indication. For instance, do you have any plan to, or is there a role for data protection authorities maybe to also to be involved and how the Delegated Act address those concerns on that?
Yeah, thank you for this question. So indeed, whilst, I mean, as you can understand, I can't really go into a lot of details. However, we have, during the preparation phase of the Delegated Act, we have indeed taken into account and considered the data protection concerns among others, because of course there is not only the data protection angle here. So starting from the assumption that let's say, while we aim to make the data access barrier as low as possible, this comes with specific responsibilities because the data that will be accessed is important data and can contain also sensitive categories of personal data. So the way we have worked so far is that we have divided the assessment into 3 specific categories and offered specific solutions as to the safeguards that can be proposed by a researcher, either legal safeguards, but also organizational safeguards and technical safeguards. So this should be reflected in the Delegated Act. We have taken an approach that indeed goes into, assesses a risk-based approach. So depending on the type of data that would be processed, there would be additional safeguards to be provided both by the researchers, but also by the very large online platforms and search engines. In terms of cooperation with with data protection authorities, here indeed we also foresee a specific role in terms of cooperation where specific requests can or cannot be, let's say, dealt with in an easier and more straightforward way. So I think we have indeed followed this risk-based approach that hopefully can provide clarity as to, let's say, the data protection safeguards that, and not only data protection safeguards that can be applied in this context.
Thank you. Thank you very much, Veronique. Maybe I pass the floor now to Paddy. Can you, given this mention to also the legal, technical, and governance aspect, can you develop a bit on the legal safeguards that might be needed for this data access request?
Yeah, thanks. I thought I'd maybe also just briefly respond to some of the previous comments. Where just maybe also clarify what I was saying, because Claudia mentioned that, like Paddy said, there's so much data already available. That's not quite what I intended to say. It was rather that there's a lot of experience from lawyers in wrangling these legal requirements. So there are long reports by Edmo, for instance, all coming from the fact that there is very little data available, right, and trying to make that possible. So it's starting from a point of a lack of access, but lots of legal knowledge. That was the point I was trying to convey. Of course, it is a fact that there's a necessity requirement in Article 40. You need to demonstrate the necessity of your request. So if the data is fully available, then you won't need to request it. But that's also maybe a reassurance to industry that I don't think it's very likely that there are going to be many researchers doing that. Because, of course, for researchers, this is most likely, even if it's implemented well, to be quite a high barrier. It's something you're only going to do if you have a lot of time, a lot of funding. I doubt they're really going to be requesting a lot of stuff that's really available, right? So that's a concern I think I can take away, hopefully. Also, just to point out that sometimes there will be things that are available, but then they're like relevant, linked, for instance, metadata, which aren't available, which you want to request. So then to have a firm rule that available data can't be requested could kind of mess things up. Another point that was raised is that the data should exist, right? And here I think, although of course we're all waiting for the Delegated Act, we can't wait for the clarifications there. This is another point where the DSA itself is actually very clear, because there is this amendment procedure where one of the grounds is that the platform does not have access to the data, right? But it also is very clear that in those cases, it's an amendment procedure, not a refusal, right? That the platform should then propose alternative means of answering the researcher's question, right? So, of course, the reason it was designed this way, I think it's one of the better design features of Article 40, is that, like Kirsty mentioned, it can be very hard to design your request. A priori, you don't necessarily know what data the platforms have, right? So it's always going to be a bit of a guesswork at the start. And that's precisely why then, if you don't precisely articulate the data that the platform already has, they need to be kind of forthcoming in trying to address that. Like Kirsty said, also I think it would be helpful to have something like catalogs or lists or clarity from platforms as to what kind of data is available. That's a recommendation I'm seeing coming from many people. I will note that we don't want these things to be exhaustive or limiting or constraining the possibilities for researchers, right? There's a risk, for instance, that certain disciplines or forms of research will then be focused on, whereas I think one of the great strengths of Article 40 is its flexibility, right? It's almost like we can think of it like a FOIA system where, it doesn't limit ex ante what things can be requested. So I think a lot of, courtesy, no offense, but there's a lot of communication scientists, right, who tend to be very present also in Edmo, for instance, and they're likely going to focus on content and user data, for instance. But looking at the CPDP audience, one of the questions I've heard asked by researchers is, well, what about the privacy features that platforms have? What are the usage rates for them? Or maybe what kind of internal research have platforms done to test which design options are less likely to be used, right? There are all sorts of questions you can conceivably ask from Article 40, which are outside of that typical kind of mainstream communication science bubble, and many interesting ones for privacy researchers as well. Yeah, I'll leave it at that for now.
Thank you, Patty. Many interesting questions. I pass the floor now to Kathy if she wants to react or add something on that.
Sorry for already looking very impatient. But I want to add some, I always try to bring concrete examples to the high-level discussions we have here. And of course, we can say we only should apply for data access if the data doesn't already exist. But even if we have access to the data right now, it doesn't mean that we understand it. So in my organization, we scrape TikTok for 2 years now, and we have like 600 data points we find which are publicly available and we can use for our research. And okay, it's against the terms of service, but that's it. But we have this like 600 data points we are looking at which are publicly available. So you can work with this data. But the problem actually is we don't understand what we have there. There are so many data points, we don't know what kind of data this actually is. So this is the problem we face. We will need code books, and that doesn't mean we only have the description of the variable, but we need to understand what this variable actually is about, what kind of processing we can do with it. So from my perspective, there will be a lot of work the platforms have to do to make available for us as researchers what we can work with, what we have to deal with.
Very interesting. Yeah, thanks a lot, Kathy, for giving your point. I pass the floor now to Claudia. I mean, how do you see these points, and also how platforms could engage on this, also while protecting their interest and on that?
Thank you very much, and fair point, Patty. I'm sorry for misinterpreting what you said. Apologies, I take it back. And thank you for all of your remarks. I mean, when I said that there's already publicly available data, I also mean that there are partnerships between providers and researchers, as well as data that is made available through transparency reporting obligations, particularly right now related especially to disinformation, elections, and advertising, but hopefully there will be more. All fair points that you have highlighted. I think the DSA will really serve to streamline all of these as a great tool to streamline all of these requests. But for us, this is a two-way street, and providers also need to make sure that researchers are treating the data securely, and we would like to see some safeguards introduced, such as, for example, for the DSCs, we would like to see them make the decisions public, and so providing a way for providers to contest the decisions if they do know that some researchers are abusing these requests, asking DSCs to monitor the compliance by vetted researchers with the terms of the requests, and also see if there's any liability possible if there is a misuse of data based on how the providing the vetting procedure and monitoring goes. And also for researchers themselves, we would like to see them be potentially liable if there's a loss of security of the data. This is, of course, something that is completely possible. We're talking about something that is very technical and potentially sensible data, maybe not sensitive, but sensible. So, of course, in the end, one of the things that I would like to remind everyone, although it's not maybe very popular, but providers are also liable first and foremost in front of their data protection authorities, so they need to know that the data that they share is also being treated in a secure manner. I hope this answers the question.
Yeah, thanks a lot, Claudia. I see the different perspective and also the challenges of balancing out. So, Kirsty, do you want to react also? I mean, you also mentioned you are you will be working with Irish researchers, but also with researchers maybe from different countries. So, can you give us also some input on this?
Sure. So Ireland has been cooperating with other DSCs in doing a national mapping of research community. Now, I will say the caveat of that is it only covers member states, so it obviously doesn't apply to the very excited US researchers in the rest of the world. But that is something we've been doing to really understand the research community's understanding. And even to that point that you made, Paddy, you know, we have already noticed that there's sort of differences across different disciplines, that some of the people who are perhaps more technically equipped in computer science and those kinds of areas, some are just largely unaware of Article 40 and unaware of what could happen with it. And some of the more communication style scholars have been very excited, but perhaps with a lot less of that base knowledge of how they would need to handle the data. So there's certainly things that I think we can work on there in cooperating with the research community and helping people to understand what's available. And something that I would also really stress is that, you know, I see the potential right now that there's a lot of really great proposals, a lot of really great ideas that would have a big impact, but that those researchers may perhaps not have the adequate knowledge they would need from a data protection standpoint to make successful applications. And so what I would really stress, considering I'm talking to data protection people, is that I think there's a lot of opportunity there for thinking about how can that knowledge be shared, how can we help upskill researchers to understand more about what are the requirements, what do they need. And I would also say too, from a DSC perspective, it's something we're very interested in. If you have papers, reports on this topic, we're paying attention and are very interested in what you have to say. So please do engage with that as well, because I think it's something that it's such a massive part of this process is the data protection side. And I think that there is a bit of a knowledge gap at the moment that we really need researchers to help fill.
Thank you very much for giving this additional input. I think now we have 20 minutes, so we have time for questions. I would like to maybe see if there, should I give my mic?
Good morning. Thank you for a super interesting panel. My name is Shoranaz. I have a question primarily for Kirsty. I'm just really interested. I understand the problem with data protection, but I'm also a bit anxious about company confidentiality claims preventing access. And I'm not a DSA expert like you are, but can you perhaps enlighten us how you will be able to deal with such conflicts of interest? And will you have like a decisive voice? Can you order access? What are your legal powers to enforce the rights of researchers? Thank you.
So with the parameters of what we know now, obviously we might get more clarity in the Delegated Act, I'm sure we will. With what we understand now is that in that amendment process, the platforms can make their amendment. That would be based on the grounds that are already outlined in Article 40 that Paddy mentioned around what they can say, no, we cannot provide this. And also, as Paddy mentioned, they will have to provide an alternative. As of yet, we can accept or reject that amendment. If we reject an amendment and the platform disagrees, we're not yet sure what the procedure will be. Yeah, so we don't have the clarity on that yet. I believe that is something that will be addressed in the Delegated Act. And obviously there will need to be a process there because I'm sure there's a high potential that situation could end up happening. But I mean, at the end of the day, I would also see it that the DSA is at the end of the day designed to make sure that companies are complying with what their obligations are. So there would need to be a strong argument for why they're denying that data. Would you kind of agree with that?
Okay.
Very briefly.
No, I just wanted to confirm that this is indeed the approach that we are following when drafting and preparing the whole procedure.
So I'll briefly note also on the trade secrets issue, which I think our confidentiality is a very important one. Concerns me much more than data protection as well. I think data protection, we have the answers quite clearly. is there's great language in both the Digital Services Act and in the Trade Secrets Directive to confirm a very kind of narrow reading there. So I think the legal arguments are there. The question is whether our institutions will take them up. So I'm thinking, for instance, of the fact that it's not an exception for trade secrets or confidentiality. It's a balancing test, right? It's about significant vulnerabilities. So it's not enough to demonstrate that this might be a trade secret or confidential information. There's in the recitals, it says that commercial considerations of the provider should not lead to refusal of the request. In the Trade Secrets Directive, we know that trade secrecy, the consensus in the literature is that it's not an intellectual property right? And it does not, for instance, rule out lawful, like trade secret rights only prevent unlawful access to information. Trade secrecy law does not constrain the legislator in creating transparency mandates. So I think there are many arguments such as these that need to be really kind of reiterated and made clear so that DSEs and the Commission and courts are not deterred by this erroneous assumption that it's confidential, therefore we can't have researcher access.
Okay, thanks a lot. I think there was 3 questions now, so there, yeah. No, sorry, Claire, okay. Go ahead. Yeah.
Hi, Claire from the Mozilla Foundation. Thank you so much to the panelists for being here this early, also for all the work that you've been doing on this topic. My question, I know the focus of this is on Article 40 as a whole, but thinking about Article 4012 and the public data aspect, it's actually a procedural question, so maybe Veronique would be best able to answer, but I'm wondering to what extent the Delegated Act will cover this, and what possibility there would be then for guidance afterwards, given that, as we are seeing with the programs that are currently available for public data, there is a huge amount of ambiguity and disparity. So there would be a great value in having some kind of harmonized standard.
Yes, thanks for the question. No, I can confirm that the Delegated Act focuses on Article 44. So the whole, vetted researcher procedure and access to non-publicly available data. Now, in parallel, our enforcement work is indeed focusing on the implementation and the compliance with Article 4012 by very large online platforms and search engines. I'm not sure you were already here at the beginning, but we indeed included already in 4 of the opening decision, out of 4 of the opening decisions that we have already against the platforms. 3 of them reflect a compliance issue with Article 4012. So that is something that we are looking very much into. We have also sent a set of horizontal requests for information to all of the designated platforms under our supervision to provide us with specific answers on access to non-publicly available data. So this is a stream that, at least on the side of the Commission, we are working on in parallel.
If I could ask a follow-up, actually, because I understand that compliance with 4012 is a subject of some of the ongoing inquiries, but does that affect the possibility of the Commission to produce actually soft guidance on the topic?
I would need to get back to you on that, but at this point in time, I think that we are just working on, compliance assessment. I'm not sure about the guidance at this point in time.
Thank you.
Hi, my name is Nina de Jong. I work at the Dutch Data Protection Authority, and I also participated in the EDMO pilot. And I think really great work has been done there, so thank you. I have a concern when it's about harmonization and application of the data protection requirements. Now in the Netherlands, we are waiting for the implementing regulation for the DSA. It's about to finalize, and in the regulation in the Netherlands, we've been awarded with an advisory role to our DSC when it comes to the data protection requirements. What I also saw is that in other member states, this is not the case. So it means that, for example, in Ireland, it will be the DSC who will look at the data protection requirements. we are very happy that we have this advisory role, because now we have the opportunity to apply our expertise. So this makes me think of, will researchers then, for example, more easily go to Ireland, because there the Dutch Data Protection Authority will not have a formal role, which for me means that the level of data protection will be perhaps lower. Do you, I think I'm looking at the European Commission at this point. I know we have to wait for the delegated act, but do you share this concern? And will it be reflected in the delegated act as well?
Yeah, I think it's a very, very valid question, which we have also considered when drafting the delegated act. However, I personally believe that this, let's say the data protection compliance and let's say the argumentation also, the demonstration that data protection requirements are fulfilled will be not left in the hands of one actor only. But I mean, the researcher as such will have to do its homework and demonstrate certain specific requirements, and the digital services coordinators will also have the possibility to assess these requirements, but also consult the Data Protection Authority. So in my view, the risk is a bit more limited, because the competencies and the assessment is shared and would be shared between the actors. So there would not be a specific actor taking all of the decision, but there would be possibilities to consult and involve other actors, including data protection authorities, where necessary, and where considered necessary due to a specific difficulty also in analyzing a specific data access application. So we hope, I mean, I personally hope that this will be clearer once the delegated act is out, but this also gives me the possibility and the opportunity to encourage you all and the various authorities to intervene also when the data access delegated regulation will be publicly available for consultation, because this will also be useful to us to integrate any input that we may have not integrated or that may not be clear enough.
Yeah, and I want to add, from a researcher perspective, we want to do things right? We want to have guidance and help with setting up our research GDPR conform. So for us, it would be super awesome to have someone we could talk to who helps us set up the infrastructure, the safeguards. So this is what we as researchers actually searching for, is people who can help us set up everything. So I would love to have more data protection, data security people involved in the Delegated Act on Data Access and support researchers.
Thanks a lot. I see we have a question and then two people in the back, so I think later we can just move the mic back. Go ahead.
Okay, thank you very much. Oliver Marsh from Algorithm Watch. Before my question, I want to make, if that's okay, a very quick comment. I just really want to strongly support Kirsty's point about platforms being more proactively helpful. I've been doing platform research since 2013, and I don't think it's ever been harder to get data from online platforms. So when platforms are making previously available tools unavailable, or 42,000 euros or dollars per month, or threatening research with legal action even for quantitative data with no GDPR requirements, I really think they should be careful about complaining about burdens when regulation comes in to fill the gaps they're leaving. To my question, we in Algorithm Watch actually submitted on the 17th of February, on the day we could, the 44 access request to Microsoft around Bing, based on some research they did into election misinformation. Part of this was sending keywords and saying we are interested in certain keywords, and this is a common thing you do in platform research, keyword-based research. The concern we have is you put that data access request in with certain keywords, you can't iterate. If you sent the wrong keywords in the first time, it's kind of one-shot approach, which is a big problem for platform research. And it's more general. If you send in a data access request and you get the data back, but for whatever reason, because you weren't able to iterate on your questions, then the stuff you get back just isn't helpful. Does that mean you then have to do an entire data access request again? Is there an opportunity to iterate, have a kind of collaborative approach, which is what you would normally expect from research, but we are in a situation where it does feel quite a you get one shot, and then you get the data back, and then maybe you have to start all over again. Particularly a problem for academics who have to tie that to research proposals long in advance.
Thanks, Oliver. Maybe Kirsty, would you like to say a few words about that? And I mean, or any other speaker later. Yeah, so Kirsty, please.
Sure, yeah. I mean, I would say on that point, in the way that we are looking at the process at the moment, there isn't really the opportunity for that back and forth. And I don't know, maybe that is something that can be looked at in the future, but I think we'd also have to make sure that that was part of the way it was designed from the European Commission's perspective. But I think also just the constraints of trying to implement it in the first place is proving difficult enough at the moment. So I think that's really where our focus is anyway. And unfortunately, I think that probably does mean, and you can correct me if I'm wrong on this, but I think that probably does mean that there isn't that opportunity for sort of iterative process with the application.
Thanks a lot. Paddy, you wanted to
very
add
briefly.
on this?
That is a challenge, I think. There is, of course, a distinction again between 12 and 4, right? So maybe there are some options there with 4 that 12 doesn't necessarily have. What I would point out, like one of the stranger parts of the 4 process is that there's kind of the vetting is at once an analysis of the researcher, like as an entity, as well as an application, and it's kind of confusing that it's doing both at the same time. Whereas, you could also point to other parts of Article 40 showing, for instance, that formats could include API-based access, which that suggests much more. It's not just a one and done, here's a list of data I want. It's more of like an infrastructure you're building, right? And so one of the requests we're seeing also from Jacob Oma and the DSA Collaboratory is that you need to have institutional vetting, right? Rather than every time you request a specific slice of data, you need to go through the whole process again. So I really do hope an affordance like that can be built into the Delegated Act. Maybe it's not the first priority to get sorted, but that at least like space for that possibility is kept open for later iterations of this process.
Okay, thank you very much. I would like to take another more question. Yeah, go ahead.
Thank you. Is this working? Thank you very much for all the different comments made. Fernando Ortal-Foronda from BEUC, the European Consumer Organization. I wanted to ask the panelists for commentary on what the current state of implementation and compliance or lack thereof with Article 39 can tell us about what to expect from Article 40. Claire has just spoken, but Mozilla Foundation has recently released a stress test on the state of ad repositories. As per that study, none of them are fully fit for purpose. We have just experienced, we have recently lodged 17 complaints against an online platform that happens to be the main advertiser in Google and Meta, per data we have from the US, not from Europe, because we couldn't access this data in any of the repositories, which has hindered, actually, our ability to exercise our Article 53 rights to lodge a complaint in as much as information that should be made available over ad repositories is not there. So, for instance, we cannot determine the extent to which a given online platform is actually targeting children, which could be very meaningful in our complaint. And I have this personal professional frustration, actually, in that how Article 39 is not working sufficiently. Is that a prelude to Article 40, or are the provisions different enough so that we can expect more from Article 40 in practice than from what we currently have with Article 39, which should be more self-executing, maybe?
Okay, who would like to react on this?
Yes, I'm the only one who can say something. The way I think this is also, I mean, this is an open question. I can't really go into the details of that, but the focus at this point in time, also including like the work of related to the delegated regulation, is on Article 40. However, of course, compliance, with Article 39 is thoroughly being followed up, in at least in our enforcement team. So this is the only, I think this is all complaints and all information that we have is being taken very seriously. And we are indeed following up on the various provisions. So I think in this context they are distinct, but in terms of, let's say, compliance and supervision on the compliance with this article. We are also closely monitoring it for the platforms, for all of the platforms that have been designated so far.
Yeah, thank you very much, Veronique. Maybe another question. I think there was someone else in the, yeah.
Yeah, hi. Good morning to everyone. My name is Felix Mikulash. I'm from Neub. I'm a litigation lawyer. I have a very simple question, because in the GDPR, what we usually see is that the data access requests we do, they're not fully answered. And after a few years, we realize, oh, actually, this data was not fully provided. And here, my question would be, how do you make sure that the data is actually relevant and adequate? I mean, in the end here, the end result would be to publish something as research. How do you actually make sure that the data here is correct for your research purpose?
Okay, so maybe I think there is different perspective to that, like timeline and also research relevance. So I don't know who would like to address this question. There's some main challenges here on the. Are you considered more like the timeline of this data requests or the meaningful? I mean, we have already mentioned a bit different speakers about the need to also have a good description of the project and the data you may need, but also about the timeline, no? That this data might be relevant still for the. So I think there are some parts of the mechanisms that maybe we can address. But Paddy, you wanted to comment on this?
Well, I think it comes back maybe to the point I started with, right? That in one case in 4012, it's the platform assessing the request. And I think we're going to see very much the same issues we saw with the GDPR with data subject access requests, right? Where they're going to try to minimize and delay and obstruct in all these various ways. Article 44 is in the first instance assessed by the DSA, so that gives me slightly more hope. Although, of course, when the request is forwarded to the platform, we might see similar dynamics, but having that weight of the institution behind it, I think, is cause for optimism there. Whether it's actually verifiably true or accurate data or complete data, of course, there's a legal requirement for it to be that. There's also the auditing mechanism. I'm not sure how optimistic I'm about that for underwriting it. So another point there is that that's one of the reasons why scraping remains so important to preserve, because this is a dynamic we also see with, for instance, ad archives, where you have the official disclosure via the ad archive, but researchers from NYU and from other places have actually used scraping to show how these ad archives were incomplete. So I think one of the philosophies of transparency is that you have like an ecology, and the more different entry points you have, you can use those different entry points to verify each other. I mean, I'm not optimistic we're going to get full or complete information, but it all kind of fits together in that way. The final thing I say is that the cause for optimism with 44 is you have the DSA. With 4012, it used to be called, and that also speaks to the previous question, the crowd tangle provision, right? So there is this idea that it's working towards a fixed set of infrastructures. And the reason that works with 4012 is because it's quite specific in scope. It's the publicly available content and data, right? So there's a relatively specific set of things you probably want to have disclosed by 4012. That, there's, like we have the ad archive, we'd have a kind of crowd tangle-esque set of APIs coming out of 4012 that would be like, this is the public content and the kind of data we get through that. So if there's a way of making that work, it's actually at looking at not individual requests and litigating those every time, but trying to get these specific compliance infrastructures in place.
Okay, thank you very much. I think we need to wrap up and go for coffee. I think it was a great panel. Thanks a lot. We see there's great projects and opportunities being brought by this article. We see the many challenges we need to address, and of course, the collaboration of all the perspectives that are represented here is key. And we also hope to have your feedback also in the delegated act when it is public, so to integrate all these comments into the procedure. Thanks a lot for coming, and have a nice day.